All right, hello guys, and a very warm welcome to your NIA Negotiable Instrument Acts, that is, your Negotiable Instruments Act Rapid Revision Session. I hope you've made good use of the JJ Act revision session we did yesterday. We did initially plan on completing both in the same session, but as we saw, we ran well ahead of time only with JJ, and it would not have been possible to conduct both in the same session. Hence, this will be your last revision session, after which on Sunday you'll be all set to appear in your examinations, right? So, all the very best for that, and I hope you've been taking all of your mock tests, your rapid revision sessions, as well as your quizzes, and making full use of the resources we provide here at Lawsikho. And I'm very pleased to let you guys know that we just got the Chhattisgarh results last night, and we had 8 people appear. 8 out of the 8 people per our latest count are now Chhattisgarh judges. So they have all qualified, which is commendable news for all of us. And furthermore, an inspiration for all of you who will be appearing in the MP prelims on Sunday. And just look at these 8 students we had. These 8 students were regular students, much like yourselves, and they just put in the commitment, the determination, and showed up every day for themselves, for no one else but themselves, showed up for their dreams and their aspirations. And look at what they have achieved. All 8 of them are now judges. They have qualified and they're now judges. That is your ultimate dream. That was their ultimate dream, and they have realized it. So, of course, a huge congratulations to all 8 of them. And I just wanted to mention it so that it could help inspire and ignite the added fuel inside of you for you to go ahead with the prelims on Sunday. So, all the very best for it. And let's begin with our session now of NIA. I'll be sharing the screen. Just let me know once you can see the whiteboard. Is the whiteboard visible? All right. So, we shall be discussing the Negotiable Instruments Act. So I hope, before we start, I hope, and I am actually quite sure that most of you will have attempted the NIA examination, the NIA mock that we had conducted, and I hope you all did very well in it. So, are there any participants here who have missed the mock by any means? Just respond in the comment section. And who have missed the full length mocks, because then with the subject wise mocks and then the full length mocks, we test various aspects, and you'll be able to cover multiple layers of the same subject and make sure you are doing everything possible. So just let me know in the comment section if you have taken the mock tests, full length mock tests and subject wise mock tests, and just let me know how they were. If you faced any difficulties, as always, bring the difficulties directly to me. Uh, I am the mock team head, and I am well equipped to help out with your concerns that you shall have. So, have you appeared for the examinations? Have you appeared for the mock tests? Yes, Sundeep, have you appeared for the mock test, the full length mocks, the NIA mock that was conducted? And where are you with your level of understanding the NIA? So I'm just trying to gauge the level of preparedness for NIA. If there is any concept that you're struggling with, this is basically just a revision exercise here. But of course, if there is any concept you're struggling with, this will help you pinpoint that, and you can, while we won't be extensively and exhaustively discussing anything here, this is just a rapid revision session, you'll be able to find out where exactly it is that you need more polishing, and that's fine. You can do it in just a few hours. Don't worry. You can take up your notes, you can take up the mock tests again, you can go through the full length mocks and attempt those questions and brush up your skills. You can attempt the quiz sessions, right? So, all right, I think we must begin now. So, starting with the basics of the Act, what we are studying today is the Negotiable Instruments Act, right? Before we understand the NIA or the need for what is known as the NIA, the Negotiable Instruments Act, we need to understand what a negotiable instrument is, right? What a negotiable instrument is. The Act itself is from 1881. It was created in 1881. The date of enforcement for this Act is March 1st, 1882, and we have 17 chapters in this Act with 148 sections, right? So unlike CPC, CRPC, there are no schedules amended to it. So we have just these 148 sections split into 17 chapters, right? So like I said, we must understand what a negotiable instrument is, and I'm sure you know what it is already, but it doesn't hurt to revise it. So the essence of a negotiable instrument, what a negotiable instrument is. A negotiable instrument is a written document, first of all, right? It is a written document that entitles a specific person or a bearer of a sum of money. So, an entitlement, there is an entitlement that this specific written document confers upon a person or a bearer, right? And the entitlement is with respect to a sum of money. This sum of money has a transferability, right? And this transferability can be made, this transfer can be made by delivery, by endorsement, right? Or by both. You can do this by delivery, endorsement, or by both, right? So, in a nutshell, a negotiable instrument should be, there should be a negotiability, right? It should be negotiable, it should be transferable, right? There should be a transferability. Plus, it needs to be written, a written document, a piece of paper that makes a negotiable instrument, right? So, that is in essence what a negotiable instrument is. So, just the basics, very casual, very understandable, very easy to process. Section 1, of course, gives us the title of the Act, calling it the Negotiable Instruments Act 1881, right? And the extent. And the about the extent, Section 1 states that it extends to the whole of India, right? It extends to the whole of India, but nothing in the Act contained affects the Indian Paper Currency Act. So, the Indian Paper Currency Act 1871, right? Uh, Section 21 of it. This is not what the NIA applies on, right? Or a local usage relating to any instrument which is in any Oriental language. So these two are outside the extent or applicability of the Act, right? Then, as we already know, the commencement, that was March 1st, 1882. What could be the objectives of the Negotiable Instrument Act? Of course, we can speculate that it is to regulate all these instruments, it is to facilitate the transferability, it is to facilitate the transactions of all these instruments. But let's just recount the objectives of the NIA Act. First of all, it facilitates the settlement of payments in business, facilitates settlement of payment in businesses. You have these instruments move freely and legally from one holder to another, and there is a free transferability of these instruments, which makes it quite convenient. Then it gives legality and legal protection to different kinds of mercantile instruments. Within businesses, within trade, there are a variety of instruments, a variety of modes of payment, a variety of things that are transferable. That is what we call instruments here. There are a variety of these that are transferred, that are oscillated to and fro from all these partners and all these persons of interest in mercantile trades and etc. And these demand legality first of all and legal protection. So that is exactly what the NIA does. It also provides orderly and authoritative statement of rules for these instruments, for these negotiable instruments. It provides procedures and obligations. It sets those out. What is the proper procedure in case there is some kind of fiasco, in case there is some kind of dispute? How do you discharge these? How do you dispose of these instruments, right? And it also regulates the different types of instruments, providing different sets of instructions for different types of instruments. In addition to that, it explains the capacities and liabilities. Now, we were talking about procedures and obligations, right? Rules for these instruments, but there are also capacities and liabilities for the parties involved. So it also sets those out, and it also creates a faith in the efficacy of business transactions, of business and banking operations and transactions with respect to these instruments. So it creates an overall atmosphere of legality, basically, an overall atmosphere of faith and trust in these. When there is legality, when there is legal backing, things become a lot more trustworthy and reliable. So that is what it does as well. So these are the objectives of the NIA. I hope we are all following so far. Let me know in the comments if there is any query. I'm keeping an eye on the comments as well. All right. Now, with respect to NIA, negotiable instruments, uh, or anything that is transferable, or when it comes to title or such, there is a general principle. The general principle, as we know, and we have studied many, many times, is nemo dat quod non habet. That is, no person can transfer a title better than the title he himself has, right? Or if a person himself does not have a property, he cannot confer it upon another person, right? But this thing, no person can transfer a title better than the one he has, is not applicable in NIA. NIA is an exception to this general rule, because we will find that in NIA you're transferring something which you might not necessarily have yourself, right? So, you basically in NIA, if you're a person, you take a negotiable instrument in good faith and for value, right? Even if you take it from a finder, even if you take it from a thief, right? So you take a negotiable instrument, not just anything, a negotiable instrument, something that has transferability, that confers an entitlement upon you. Here, the finder might not have the title himself already, and might this principle might exclude him, right, from transferring it. But NIA acts as an exception to this rule, right? So let's remember that. So you may take, it's not advisable to do it, but you might not be aware that he's just a finder or a thief or whatever, and you may take that instrument. You may find yourself having that entitlement because you did so in good faith. So NIA constitutes an exception to the general rule of nemo dat non habet. All right. So, with respect to what a negotiable instrument must look like, the NIA specifies several requirements, right? So there are certain areas that a negotiable instrument must fulfill, certain essentials. First, it should be in writing, right? It should be in writing. It can be in handwritten notes, it can be typed out, whatever, printed, but it should be in writing. Second, it should be easily transferable, right? It should be transferable ad infinitum, as many times as you want to transfer it. It should be capable of being transferred as many times as it needs to be transferred, easily transferable from one holder to another. And the time of payment of this instrument must be certain, right? Time of payment must be certain. The payee, right? The person to whom you're paying this also must be certain. And this payee, this person can be an artificial body person, it can be a corporate body, etc. It must be an unconditional order. It must not come along with conditions. It must be an unconditional order, right? An unconditional promise for payment. It must have no strings attached. And it must be stamped, right? So the stamping of a negotiable instrument act is necessary. The stamping must be done keeping in conformity with the Indian Stamp Act of 1899. All right. So those are the general essentials that negotiable instruments are to follow. Moving on next swiftly to kinds of negotiable instruments under the Negotiable Instrument Act. So we see Section 13 illuminate us on this. Section 13 of the Act talks about various kinds of negotiable instruments, and it tells us that negotiable instruments include promissory notes, bills of exchange, and checks, right? And these can be payable to bearer or upon order. Okay? That is generally the kinds of negotiable instruments we are here dealing with. See, with respect to these negotiable instruments, like I mentioned, the essentials, right? The essentials I just mentioned, such as there must be a date, there must be stamp, the acceptance must be certain, so on and so forth. We can go to section 118. So we in this session we are going by concept. We are not going by section as we did in the Juvenile Justice Act yesterday. We are going by concept and seeing which concept fits what. So the sections might be here and there, but this is per the concepts involved. So section 118 talks about certain presumptions of negotiable instruments. So whether the negotiable instrument is this, or any of these, or this, there are certain presumptions that operate with respect to negotiable instruments generally. What are these presumptions? As outlined in section number 118 of Negotiable Instruments Act, what are these presumptions? Presumptions are made with respect to the time of payment. Presumptions are made with respect to the existence of a consideration. So there is a presumption made for consideration. The presumption is that every negotiable instrument was made or drawn out for consideration, right? Then it is that every negotiable instrument had a date. It bore a date. There was a date. It was bearing a date, the negotiable instrument, and it was made or drawn out on that exact date. As I said, the date must be certain. Then there is a presumption as to the time of acceptance. The assumption is that every negotiable instrument was accepted within a reasonable time after its maturity, right? Sorry, before its maturity, on a date before its maturity. Then there is a presumption with respect to time of transfer. Time of transfer, that every transfer of negotiable instrument was made before the negotiable instrument matured. Then there is another presumption with respect to order of endorsements. right? That the endorsements that are on a negotiable instrument were made in the order that was specified in the negotiable instrument itself. They were not made in a haphazard order, they were made in the order as ordained in the negotiable instrument. Then there's a presumption as to stamps, right? That they were duly stamped, as we just saw, is a requirement for negotiable instruments. That another one is that the holder of it was a holder in due course, right? It was lawful, it was a holder in due course. So these are also some essentials that are presumed for a negotiable instrument legally done. Of course, the legality is presumed, and these things are also presumed. So important to bear in mind that these essentials also, actually these essentials are so intrinsic to a negotiable instrument that they are assumed to exist, presumed to exist. All right. Now we move on to chapter number 2 of the Negotiable Instrument Act, which starts from section number 4. Chapter 2 talks about the kinds of negotiable instruments, the parties involved in the transaction of negotiable instrument, etc. So let's begin with promissory notes, right? Like we just mentioned, section 4 talks about what a promissory note is, right? Again, it is itself a negotiable instrument. So first of all, it must be in writing, right? Certain things are excluded from being a promissory note. These are banknotes, currency notes, right? So let's also remember that. Then a promissory note must be unconditional, as we saw again. So basically, we are just recounting so far here the essentials of a negotiable instrument itself. The parties of this must be certain. Um, and it must be the payment that is talked about in the promissory note, the thing, it must be in money only. So the value side of it, right? The payment side of it is in money only, right? So apart from this, of course, it must be signed by the person making it, by the maker. So section 4 tells us, whereas currency notes and banknotes might fulfill some of these some of these essentials, they are not promissory notes because we are at the outset excluding them. What we do need a promissory note to be is to be in writing, is to be unconditional, is to have certain parties, is to be in terms of money only, the payment must be in money only, and is for it to be signed by the maker himself, right? So essentially the promissory note is a legal financial instrument, right? So these are the essentials, and it is interesting to note that in a case, a few other essentials were also added by the esteemed judiciary. Actually, two cases take it up. These, I'll discuss the essentials first. So these are the two essentials added. The first is that there must be nothing else in the promissory note that is inconsistent to the character of the instrument. So anything that clashes in the promissory note with the character of the instrument, with the character of the promissory note itself, or with the character of a negotiable instrument, should not be there. So this inconsistency should not be there. That's one essential. And then the parties involved must intend for the instrument to be a promissory note. So there must be an intention for the negotiable instrument to be a promissory note. The cases relevant here which led to these additions are the case of Doka Jogana versus Upadrasta, case of 1997, and the case of Bahadur Nisa Begum versus Vasudev. This is a case of 1967. Basically, the 1997 case built upon this 1967 case only, and together they created the existence of these two added essentials. Okay, so that was a promissory note. What was this next thing we mentioned? Could be a negotiable instrument. It was a bill of exchange. So, to understand a bill of exchange, we go to section number 5. Most questions in NIA are pertaining to either delivery, presentment, or the nature of these and essentials of these kinds of negotiable instruments. So pay close attention. Section 5 is talking about bill of exchange or BOE, right? So bill of exchange again is a negotiable instrument. That means it is written. Again, there is an unconditional order in it. The unconditional order is to pay a specified sum of money. The specificity is very important in all of these. To a person or a holder of the instrument as directed by the instrument itself. And the bill of exchange itself is payable either on demand or payable after a specified term. So the payability can be delayed up to a certain term, after which it will become payable, or it is payable on demand, right? Now, who are the parties to a bill of exchange? So first of all, let's see the essentials. The essentials are: there must be certainty of parties. The parties should be certain. The second is, again, it must be stamped in accordance with the Indian Stamps Act of 1899. Then there should be a specific mention of date and place of payment, right? There has to be an order to pay. We said unconditional order to pay, so there has to be an order to pay, not a request or a direction, right? Not a sorry, not a command, but like there should be an order. There has to be a certain kind of direction in a sort. And time of payment must also be certain, in addition to place of payment, right? And the amount that is payable must also be very certain, and it should be clearly mentioned. Complete clarity on these fronts. And also, the consideration against must be, like we saw in the previous one too, it must be paid by way of money only. Okay, so that was the essential bit. Now, who are the parties to a bill of exchange? Who will be involved in a bill of exchange? There are three parties to a bill of exchange: the drawer, the drawee, and the payee. So let's take a bit to understand who they are and remember. So, for a bill of exchange, let's understand that this is a bill of exchange. For example, there are three parties. There will be a drawer. So, the drawer is the person giving the order to pay, or the person who is making the bill of exchange. Then comes the drawee, is the person who is directed to pay. And he is directed to pay whom? He is directed to pay the payee. So the payee at the end of the day is the person getting paid. Okay, so those are the three parties involved in a bill of exchange. Apart from this, we also have the NIA talking about the types of bill of exchange, which I will briefly mention. Four type of bills of exchange. So a lot of nomenclature that we have to understand in the NIA Act, but if we remember the flow chart of what is what, so we know a negotiable instrument can be these three things: bill of exchange, right? And all these things. And then within bill of exchange, we have the four kinds. So we have to remember the hierarchy of things. And that makes things significantly easier. Otherwise, we tend to get lost in which of these is a bill of exchange, right? And which of these is right? Which of these is a subset of bill of exchange and which of these is a subset only of negotiable instruments. So a bill of exchange can be, you can have inland bills, right? That are bills drawn or made in India, and Section 11 deals with those. You can have foreign bills, which Section 12 deals with, right? So you can have what is known as trade bills, which just signify that a genuine transaction has happened, right? And you have accommodation bills. Right? Accommodation bills are generally, for example, used in lending money, in a very informal manner. So if you're lending money to someone you know, a friend or someone, you can sign up in accommodation bill. All right. Bills can also be in sets. Sections 132 and 133 talk about that, the existence of bills in sets, right? Bill, when we say bills, remember we mean bills of exchange. Okay, so we might just use BOE or mostly use bills, but bills of exchange is what is meant. So when we say bills, that is what is signified. So bills can be in sets. You have sections 132 and 133 talking about it. So while they're in sets, they can be drawn in parts, that is in installments, right? That is important to remember as well. So a bill can be in a whole, the entire bill. It can be in sets. You can draw parts of the bill. You can draw the exact entire bill. Then we move on to the third kind, which is check. Section 6 talks about what a check is, right? Now, Section 6 of the Act states, first of all, that a check is a bill of exchange. Okay? It is a bill of exchange. And in addition to being a bill of exchange, it requires to have the quality that it should be drawn on a specified banker and it should be only payable on demand, right? So if there is a bill of exchange that is drawn on specified banker, it is a check. If it is not drawn on a specified banker, that is otherwise. You can draw it at any bankers. It is not a check, right? And after this, if it is payable on demand, it is a check. If it is not payable on demand, it is not a check, right? So apart from this, the check, it does not always have to be in the form of an image, etc. It can also be in an electronic form. So we call this as, it can be an electronic image of a check, or the entire check can be in an electronic form, right? So those are the considerations of what a check is. Apart from this, the check is also required to be an unconditional order by nature, is required to be signed by the maker, is required to bear a specified number of the amount in words and figures. We all know what checks require to be, you know, designated as checks. You need to specify the amount in words as well as figures. You need to sign it, right? You as a maker need to sign it. Then it needs to bear a date of when it's made. It needs to have a date of when it's made. The payee, person paying, sorry, person being paid must be certain, because you do write who you bear this check to, right? And then again, the check, the drawability of the check, it may be drawn, of course, on demand, but it may be drawn on demand to the bearer, or it may be payable on order. right? So those are the requirements for check. Now, what is distinguishing? We know that if this is the circle showing us bill of exchanges, checks are only a part of it. But what is distinguishing, right? Checks and bills of exchange, a common concept of clarity required. So let's just quickly write down what is the difference between, or what distinguishes every check from every bill of exchange. So a bill of exchange will generally be drawn on some person or firm. However, what did we learn about checks? Always drawn on banks, a specified bank, right? A bill of exchange requires acceptance before the payment can be claimed. You don't require acceptance for the payment. A check is made, it's already accepted, it can be drawn at any time. This can be drawn on demand, right? Or expiry of a certain period. This is payable on demand only. We learned that as well. With respect to bills of exchange, there is something called a grace period for drawing the bill of exchange. There is no grace period. If a check expires, it expires. You cannot draw it after that. If the drawer of a bill here, drawer of a bill of exchange, if he is discharged from liability, right? If a drawer of a check fails to present if the drawer of a bill fails to present it for payment, he is discharged from liability, right? It's done. But if a drawer of a check, right, suffers any damage, he will only be discharged from liability. Here, he will be discharged from liability where he fails to present the bill. But when will a drawer of a check be discharged from liability? Only if he suffers damage in presenting the check for payment due to delay, right? Something called dishonor, which we will learn about later. If a dishonor happens, the notice of it is necessary. If a dishonor of a check happens, notice is not necessary. There is something called crossing of checks. There is no such crossing for bills of exchange, right? You require bills of exchange to be stamped. You don't actually require checks to be stamped. Another key difference, a bill of exchange can never, which is payable on demand, can never be drawn to the bearer, right? But check that is drawn to bearer, it can be drawn to bearer, that is payable on demand, and it being drawn to bearer is valid here. So those are the broad differences between a bill of exchange and a check, right? So we must bear these in mind. So a few of these you'll see negating each other, crossing out each other, but a check possesses all these qualities, a bill of exchange possesses all these qualities, and the difference is what sets both apart. So I hope you understand that. It offers a bit of conceptual clarity. Let's move ahead to the crossing of checks that I mentioned. Again, you must see this being exercised a lot. It's used to kind of authenticate a holder of a check, and it is talked about in sections 123 through 131, right? So, what it does, crossing of a check, it acts as an instruction to the banker to pay the specified amount only through the banker. So, a further direction to only pay the amount only through the banker, right? That is, you have to directly deposit that check to that exact bank of the payee. And who can cross a check? A drawer can cross a check, a banker can cross a check, and a holder is entitled to cross a check, right? So crossing of a check generally looks like, if this is the check, this is what it looks like, or this is what it looks like. And there are two kinds of crossing. It is just a simple act, but the significance it carries is an added authenticity and added direction that it must be paid only to the banker of the payee. There is general crossing and there is special crossing. General crossing is discussed in 123 of Negotiable Instrument Act. Special crossing is discussed in 124 of Negotiable Crossing Act, Instrument Act, right? In general crossing, two parallel lines, what I drew right now, are marked across the face of the check, right? And the check has an abbreviation and C between the two parallel, sorry, traverse lines. This is not a general. A general crossing would look like this, right? And you have written not negotiable. And you have written account payee. That's a general crossing. Now, for special crossing, a check bears across its face an addition of the name of banker. To this, you add the name of banker. And this not negotiable may or may not be there, right? That is just what the special crossing mentioned in 124 looks like. And there's also something called double crossing discussed in 127. And you cross the check to more than one banker. Then the bank that receives these cross checks, there is a great risk in a way to those bankers, right? The banker receiving it will be called the collecting banker. So the check goes to finally a bank, the specific bank that we were mentioning, and that bank will be titled the collecting banker. And great risks are involved, right? So the banker, the person on whose behalf the check is being collected, it that person might be a fraud, right? The banker just has to go by the face of that person and has to blindly trust that person. So there is a liability protection, there is a saving clause for the bankers, and this is section 131. Section 131 states that if a banker is in good faith without having negligently acted, if he is collecting cross checks and the person who is bringing it to him turns out to have no title in the cross checks, this person will face no liability. Okay? This person will face no liability. There is that. So, section 131 prevents him from incurring any liability. So, that was all about bills of exchange, promissory notes, and checks. So there are also a few other terms that you might be tested on and they should not stump you when they come in the exam. So let me just mention them briefly. These are again kinds of negotiable instruments. We did talk about inland foreign instruments already, right? There are also order instruments. So any instrument which is payable on order, right, to a person is an order instrument. There are bearer instruments. So instruments that are negotiated by mere delivery, where you deliver something. So if you're a payee, you deliver a check to a bank, right? Whatever. Deliver as a payee an instrument to the person who will be entitled to pay you. That is a bearer instrument. Inland and foreign we already discussed. There is also something called inchoate instrument. This is dealt with in section number 20 of NIA. And inchoate instruments are such instruments which are unregistered, unrecorded, and they can only become effective when this unregistered and unrecorded thing is cured, right? When this defect is cured. That at that point, that instrument will be called an inchoate instrument. There's also something called an ambiguous instrument dealt with in section number 17. So an ambiguous instrument in a form that you don't know what they will be treated as. They may be treated as a bill, they may be treated as a note. So that exact nature is ambiguous, right? And the holder of these ambiguous instruments is given the choice to whether treat them as a bill or a note, whatever he wants to treat them as. Then there is something called a demand instrument, right? So it's an instrument with which no time for payment is specified. That is, it is payable on demand always. That will be your demand instrument. Again, this is A in section 19. So ambiguous was in 17, inchoate in 20. Foreign and inland, I had already discussed. This was in 11, as I said, and this was in 12. Demand is in 19, 17, this is 20. And then we have time instruments remaining, which are discussed in section number 22, right? So instruments which are payable, made payable after a fixed period of time, after sight, on a specified day, whatever it is, or on the happening of certain things. So there is a certainty as to when they will be paid, unlike the demand ones, right? So time instruments are those. Now, those were the other kinds of titles for instruments used that I wanted you to become familiar with in case you're not already. Next, we'll take up the terms related to payability of instruments, right? So the terms used are at site. You will see term at payable at site. You will see the term payable on presentment of instrument used, or you will see the term payable after site used, right? So these are discussed in section 21. Basically, being payable at site or on presentment means the instrument is payable on demand. But being payable after site means if it is a promissory note, it means it is payable after presentment. So after you make the presentment of the instrument, after that it is payable. And when it comes to a bill of exchange, being payable after sight means it is only payable, it is deemed to be only payable after you accept it, right? Or after noting it for non acceptance. There's another thing that can happen to a bill, which is protest. So after there is a protest for non-acceptance, and whatever happens after that, only after all of that thing is put to rest is this made payable. So that is the significance of the term after sight. At sight and on presentment mean on demand. So whenever you want to, they will be payable. Section 21 was enumerating on the payability terms. So these three payability terms. So again, with respect to the payability, when does an instrument become payable? When can you encash it in layman terms, right? So that is also known as the time or the period of maturity. So what is the period of maturity? Section 22 says that the maturity of a promissory note or a bill of exchange is the date on which it falls due. So the date on which it falls due is already mentioned in these certainly. So that will only be followed, and that is considered to be the maturity period. Section 22 further gives a grace period. I told you there's something called a grace period which applies to bill of exchange, but also as well as to promissory notes. So if a note or a bill, a promissory note or a bill of exchange is not expressed to be payable on demand, what happens? Or at sight or on presentment, a 3-day grace period is allowed, right? After the initial day when it should have been made payable, right? So a 3-day grace period is allowed from that. Okay, so that is the extent to which it goes. Then there are questions about, and these can become situation based questions about computing the date of time of maturity. Section 23 talks about computing time of maturity. And there is an easy way to understand this, though the section is quite vast, appears to be quite confusing. There is an easy way to understand it if we understand it in tiny chunks. So let's take it apart. And if, with respect to a negotiable instrument which is payable on a specified date, let's take those up. So, section 23, let's only deal with a negotiable instrument which is payable on specified date, right? What is the maturity period? When does it become payable? So, of course, it is either the specified date, or we just talked about the 3-day grace period. That is the extent to which it becomes payable. Situation 1, situation 1 was that. Situation 2, if it is a negotiable instrument that is payable on a stated number of days, so certain days after date or after sight or after the happening of a certain event. So contingent on certain events, but certain days after it. In that case, it will be either payable on the date when it is drawn plus 3-day grace period, or date when it is presented for sight plus 3-day grace period, or date when event happens, so this one, plus 3-day grace period. All right, clear so far? Third scenario, if it is a negotiable instrument if it is a negotiable instrument that is payable on a stated number of months after date or after a certain event, what is the maturity, what is the payability? It is the same date of the relevant month that is the date on which it is drawn plus 3-day grace period, or it is the same date of the relevant month when it is here on the day when it is drawn, or here on the day when it is presented for sight, the corresponding date of the relevant month for when it is presented on site plus 3-day grace period, or the corresponding date of relevant month when the event happens plus 3-day grace period. So as we can see, quite easy to understand all the scenarios mentioned in section number 23. With that, we have completed all the contents, important contents of chapter number 2. We will move on to chapter number 3, which talks about the parties that are involved in negotiable instruments. Right? So we have sections 26 through 45A in this, of which we'll be discussing the important ones. Section 26 is pretty important because it talks about the capacity. Now, it states that every person can make a negotiable instrument. Every person who can bind himself or be bound by drawing, making, endorsing, accepting, by the delivery of and the negotiation of a negotiable instrument, right? And if he happens to be a minor, he may draw or endorse or do any of these things. He may do that. He may do that. So the drawing, the endorsement, the delivery, the negotiability, right? He may bind all parties in it but himself. So he may make all these things a happening, right? He may make all these things a possibility, but he may not bind himself in the same negotiable instrument, right? So that is for the capacity of making negotiable instruments. Next up in chapter 3 is section number 27. And section 27 talks about agency. Again, the same concept as in 26, that a minor may do it. Sorry, section 27. The same concept as in section 26, that anyone who is capable by law of binding himself per section 5, per section 26, he may bind himself or he may be bound by an agent who is authorized. So that tells us that agency is allowed in NI. 28 talks about further the liability of the agent. So an agent who signs his name, an agent signing his name to a negotiable instrument, but he is not indicating the fact that he is signing as an agent. So he is not indicating his capacity, his liability, and his position. And he is not indicating that he intends to incur personal responsibility. He is still considered to be personally liable on the instrument. So that is the extent of the liability of an agent, right? But the exception here is that he will not be considered to be personally liable if to those person towards the action of those persons who are forcing him or inducing him to make such signature. So if he's being forced to take up this personal liability, he will not be personally liable towards the actions of those people who have forced him to do this. The similar liability goes on for legal representatives of deceased people, talked about in section number 28, 29. 28 discussed the agent's liability, and a legal rep or a legal representative signing his name on a deceased person's negotiable instrument is also personally liable, except for where the deceased person is expressly limiting the liability of the legal representative. Next, we talk about the liability of another party involved, that is the drawer, right? So, the drawer of a check or a bill of exchange is bound, his liability is that he is bound for dishonor. Whether the dishonor happens by act of the drawee or acceptor. The drawer is bound for dishonor and he is bound to compensate the holder of the check. So, the person who has suffered at the end of the day. And here the dishonor thing it is required that due notice of the dishonor should be given to the drawer. So that is the extent of liability of drawer discussed in section number 30. In 31, we talk about the liability of drawee of a check. So the other side of it. So a drawee of a check who has sufficient funds in his hands or in the hands of the drawer, he will be liable to pay the full amount on the check when he is duly asked to do so, when he is duly required to do so. If he fails, if the drawee fails to make the payment of the amount of the check where he has sufficient amount, he then has to compensate the drawer for the loss he has caused him because of failing for paying the amount. Okay. Next parties in line are next parties in line are makers of notes and acceptors of bills. Right? The liability here is that the makers of notes or acceptors of um, bills are bound to make the payment of the amount, so bound to pay the amount at maturity, as is written in the tender, as is written in the bill. The acceptor is bound then the acceptor is bound to pay the amount to the holder on demand or after maturity. And again, if either of them, the maker of note, acceptor of bill, fail to do so, they have to compensate the party concerned. So any party concerned that has suffered a loss because of their failure to pay this amount has to be compensated by the maker of the note, acceptor of the bills. All right. Next, we move to the liability of an endorser, covered in section number 35. Right? So, who is an endorser? It is a person who endorses or delivers a negotiable instrument, right? And so, if a person endorses or does so, he has to compensate if there is a failure then in the activity that he endorses. So he has to, before the maturity, he has to compensate all the holders, right? The subsequent holder, because he has made the act of endorsing it, right? And again, like the drawer, here due notice of dishonor has to be given to him, because only if the dishonor happens will his endorsement fail. His endorsement fails, then he has to, before the majority, compensate the subsequent holder. Next, section 36, liable of prior parties to holder in due course. So a holder in due course, who is liable towards the holder in due course. So a party prior to the holder over there is, until the instrument is duly satisfied with respect to this holder in due course, the prior party will be liable towards him, right? Then there is the kind of liability of makers, drawers, and acceptors. Section 37 makes them principals. So, Section 37 puts the title of principal debtor on a maker of an instrument a drawer of an instrument, an acceptor of an instrument, acceptor until acceptance. They are the principal debtors, and all other parties also liable, but they are liable as sureties for maker, drawer, and acceptor. So that is the dynamic of liability. Next comes the liability in section number 38 of prior party. Section 38 discusses prior party as a principal, states that he is a principal debtor to subsequent party. So there is a dynamic of liability even between parties. Each previous party is a principal debtor towards the next party, towards the subsequent party. Section 39. We see section 39 discussing suretyship, right? And it states that when the holder of an accepted bill contracts with the acceptor discharging the other parties, so there is a contract between the two, and this is done whether under 134 or 135 of the Indian Contract Act, he may expressly reserve his right to charge the other parties. Right? An important dynamic to remember in suretyship under the NI. So when a holder of an accepted bill is making a contract with the acceptor while the acceptor is discharging other parties, the whole, and it's done under 134 or 135 of Contract Act, the holder may expressly reserve his right to charge the other parties. Now, the endorser's liability, does it exist forever or does it end? Section number 40 speaks about it and states that when a holder impairs the endorser's remedy against a prior party without the consent of the endorser, the endorser stands discharged of liability as if the instrument has been paid, as if the entire thing has been done, the endorser becomes free of liability. Now, there might be certain situations where the freeing of a person from liability is not as easily done. Section 41, for example. So, if there is an acceptor of bill of exchange, right, and the endorsement is forged, even though the endorsement is forged, the acceptor does not stand relieved. So his liability still stands. Section 42, similarly. So if there is an acceptor of a bill of exchange and the bill of exchange is drawn in a fictitious name, again, the acceptor's liability towards the future holders in due course is not relieved. Right? So are we following so far? We have to move on to the other chapters too swiftly. So now there might be certain situations where a negotiable instrument is made, drawn, etc., without a consideration, and Section 43 deals with that. If a negotiable instrument is made, drawn, accepted, endorsed, transferred without consideration, or there is a or there is a failed consideration, no obligation for payment is created. Right? So when such a thing invites parties, when such a thing involves multiple people, the subsequent holders, they may recover the money due from the transferor for consideration of any other party. So the transferor becomes the person paying it. What happens if there is a partial failure, not an entire failure of the money bit, but there is a partial failure? So if part of the consideration, not the entire consideration has failed, but part of the consideration has failed, what is done? The sum is accordingly and proportionally reduced. Okay, which a holder was entitled to receive, the sum is accordingly reduced. The part that has failed is reduced from the entirety of the consideration part. Final one, 45A, that we were talking about. So this is 45. 45 deals with this. Sorry, 44. So it involved money. 45 actually deals with partial failure of consideration. So this was about money. What happens when the partial failure of consideration failed, but it did not involve money? Right? So the portion that failed out of the consideration was the portion not including money. So here also the sum on which the holder had a right, had an entitlement, again will be proportionally reduced, because the part that failed did not involve money, the remainder part does involve money. And now 45A, 45A deals with the holder's right to duplicate a lost bill. So if a bill of exchange before it is overdue is lost, the holder can apply to the drawer to give him a duplicate bill of the same tenor, of the same amount, and of the same values. And he can get security to indemnify him against all persons. And if the drawer refuses to do so, he may be compelled to provide it, because otherwise it becomes a issue of security, because the bill is lost. Right? So those were the parties and the relations and liabilities and everything involving the parties with respect to negotiable instruments. Now we get on to the actual negotiation that is contained in chapter number 4. We have sections 46 to 62 discussed here, with 46 dealing with the delivery. What does the delivery of a negotiable instrument mean, right? So you can make, we talked about terms such as making a negotiable instrument, accepting, endorsing it, etc. It is done by delivery. Delivery can be actual delivery, it can be constructive delivery. Okay, it can be of two kinds, actual or constructive delivery. So in respect of these negotiable instruments, so all three, promissory note, bill of exchange, or a check, where it is payable to bearer, it is negotiable by delivery. Right? It is negotiable by delivery. Where a promissory note, bill of exchange, or a check is payable to order, it is negotiable by the holder by endorsement. We talked about this in the very first definition part only. It is in this case negotiable by endorsement plus delivery. So both have to happen. Where it is payable to bearer, it is only negotiable by when just delivery does it. But here you need both endorsement as well as delivery. Now let's talk about negotiability by delivery in section 47. So, negotiability by delivery in section 47 goes something like this. So, negotiability by delivery. Negotiability by delivery is permitted when a promissory note, bill of exchange, or check is payable to the bearer, as we already saw. So, here, subject this section, the negotiability by delivery states that subject to the provisions of section 458, subject to the provisions of section 58, where a negotiable instrument, where that is a promissory note, a check, or a bill of exchange, is payable to bearer, it can be negotiable. It is negotiable by delivery, right? So by delivery, the entire thing is completed. What happens where it is negotiable, payable to order, right? Again, subject to the provisions of section 58, where a promissory note, bill of exchange, or check is payable to order, it is negotiable by the holder by endorsement plus delivery. What is meant by the term endorsement? Endorsement refers to signing it on the back, right? It refers to signing it with the intention of transferring it. Or you can sign it on a separate bill and attach it to the instrument, right? And endorsement itself can be of various kinds. You can make endorsement in blank, you can make endorsement in full, there can be special endorsement, you can conditionally endorse something, there can be restrictive endorsement, there are various kinds of endorsements as well. What is the effect of endorsement? What do you do by endorsement? Though section 50 talks about the effect of endorsement, and it states that endorsement of a negotiable instrument followed by delivery transfers to the endorsee the property therein that was referred to in the instrument, the property with the right to further negotiation, right? So that is when you are completely endorsing the thing. But if it is restrictive, etc., of certain rights, then those restrictions will, of course, apply. Section 58 talks about who may negotiate a negotiable instrument, right? So every maker, sole maker, so only the person do it, every sole maker, every sole drawer. So a drawer may negotiate, a payee may negotiate, an endorsee may negotiate, or all or several joint when it comes to a joint situation, all or several. When it is sole, only these people. When it is a joint situation, all or any of them, any maker, any drawer, any pay, any endorsee, or all of them when it is a joint situation. So, unless the negotiability by some written clause or some rule has been restricted or excluded, this is the general principle that all these people can make negotiability, they can negotiate. Section 53 elaborates upon the rights of a holder who derives a title from a holder in due course. So a holder in due course is here, and then there is some other holder who is deriving his title from the holder in due course. So if a holder of a negotiable instrument is deriving his title from holder in due course, he has the same rights that this person has. So the rights also transfer. Section 53 provides legal backing to this. So this is often a question asked, which section entitles a holder of an instrument to have the same rights as the holder in due course of that instrument. Section 57 is important next. It states that a legal representative of a deceased person, bear this in mind, cannot negotiate by delivery cannot negotiate by delivery. A negotiable instrument payable to order and endorsed by the deceased before he was deceased, but not delivered. So if it is not delivered, but it has been payable to order and endorsed by the deceased person, but not delivered, it cannot be negotiated by the legal representative. Okay. Section 58, an important section, deals with instruments that are obtained out of unlawful means or are obtained out of unlawful, are obtained for with unlawful considerations. What happens to those instruments? Section 58. So, Section 58 states that when a negotiable instrument has been lost or has been made or has been obtained from any maker, acceptor, or holder by means of an offense, so unlawfully obtained, or it has an unlawful consideration, no holder, no possessor, or endorsee who claims that the person who found or obtained, found because we said it was lost, obtained because it was unlawfully obtained, obtained the instrument, is entitled to receive the amount. Right? That was discussed. No person is entitled to receive the amount unless the person is actually, right? Unless the person or someone he is claiming it for is actually the holder in due course. Okay? So that is about unlawfully obtained, lost, because if you find it while you're not really the correct person to hold it, you're not rightfully entitled to it, and you found it, that is also you unlawfully acquiring it. Next, we move on to chapter number 5, which deals with presentment. Chapter number 5 of NIA dealing with presentment discusses sections 61 through 77. So presentment just means presenting the negotiable instrument to the maker, acceptor, drawer for acceptance payment, right? Or on site. So you can make the presentment for acceptance, you can make it for payment, you can make it for site. So we have to remember that presentment is only necessary for the acceptance of bills of exchange. Okay, bills of exchange acceptance requires presentment, right? And we know that a bill of exchange must be presented by holder or his authorized, duly authorized agents. And who must this presentment be made to? This presentment may be made to the drawee or the agent. Mama ये करीब बांध presentment made to drawee or his agent, right? or legal representatives of drawee if the drawee is dead, or the official receiver if the drawee is an insolvent, right? Or to the drawee in case of need, or and it is done for the acceptance. Section 62 deals with presentment of promissory note for sight. So, if a promissory note is such that it is payable after sight, after a certain period, it must be, after it is made in sight, it must be first presented by a person entitled to take that payment. It must be presented within reasonable time, and it must be presented within business hours and, of course, business days. So that is presentment. Now, the drawee, on the other hand, must be given some time to decide whether he will accept the bill that is presented to him, or he will reject it. Section 63 talks about it. So the time that is to be given to a drawee to whom the bill of exchange is presented for acceptance, he must be given 48 hours to consider whether he will accept the bill or he will reject it. Now, this 48 hours excludes public holidays. Right? And then section 64 also, if you are presenting something for payment, that was presentment for acceptance up until now. If you're presenting something for payment, if it is a promissory note, bill of exchange, or check that you're presenting for payment, it must be presented to the maker, acceptor, or drawee on behalf of the holder. And if you don't present it, if you make a default of this presentment as the holder of the promissory note or bill of exchange or the check, the other parties will not be liable to you with respect to such holdings, right? The other parties will not be liable because you simply failed to present it. So, to help you understand it, a bill of exchange, you present it to acceptor, a promissory note, a maker, and a check, a drawee, right? A check is presented to a drawee, a promissory note to the maker, a bill of exchange to the acceptor. Now, where must the presentment be made? Certain sections talk about it. Section 70, 71, Section 70 states that the presentment must be made for a place of business or the place of residence of the drawee, maker, or acceptor. And section 71 states that where there is no known place of business, etc., the presentment can be made to that person in person. So you can go up to that person and make it when you don't know any specific place of business that is officially required to be the place where you present it. Section 75 allows for presentment to agent, representative of deceased, like we discussed a few minutes over, or assignee of insolvent. Okay. Then Section 75A, which was added by the Amendment Act of 1920, states that where there is a delay in the presentment, generally we want the presentment to be made within the time it needs to be made, but the delay can be excused when it is inevitable and beyond the control of the holder, or when it is non-imputable, when you cannot blame it, basically non-imputable to the holder's misconduct or negligence or default. So you cannot put the blame on the misconduct, default, or the negligence of the holder. Now, there are also all of these situations are where presentment is required. There are also situations where presentment may be unnecessary, and these are discussed in section 76. So, a variety of reasons such as just a moment, please. Okay, sorry for that. So, so certain situations make presentment unnecessary. For example, if you have a instrument that is presentable, that has to be presented at a specific place, and that specific place is nowhere to be found, right? Or when the maker of the negotiable instrument has run part of the payment already, right? Even without presentment, you don't need to make the presentment. That already means that the presentment acceptance is there. There's that, and then there are other situations, for example, where the drawer is a fictitious person, where the drawer is a minor or a lunatic, where you are making reasonable research and you're finding out the place to be met, but the drawer cannot be found himself, right? Or the acceptance has been refused on some other ground, etc. These are situations where presentment is not required. So 76 deals with presentment being unnecessary. All right. We move on next to section 77 that deals with the liability of a banker for negligently dealing with bill presented for payment. Now, a banker is very responsible, negligently dealing with bill that was given for presentment. See, if a bill of exchange is accepted and payable at a bank, and then you present it there, and then the banker makes the mistake of improperly or negligently keeping it, dealing with it, or fails in delivering it back, and as a result causes a loss to the holder. What does the banker have to do? Reasonably so, he has to compensate the holder for the loss he has caused. So that was chapter number 5. We will move to chapter 6 now. Chapter 6 deals with provisions relating to payment and interest. So, who will you be making the payment to? What will the interest look like? Right? Of course, the payments of the amount due on a due on a negotiable instrument will be made to holder of negotiable instrument, right? So 79, section 70, this is section 78, that the payment will be made to a holder of the negotiable instrument. Section 79 talks about interest rates being specified. What do you do with the payment when the interest rates are specified? Section 80 talks about what do you do with the payment when the interest rates are not specified. So if it is specified, of course you will go as per is written on the bill of exchange or the promissory note. You will operate as normal. You will calculate it from the bill of exchange and promissory note. You will add it to the principal amount. You will do the normal calculations, and it will be done from the date of instrument and done until the amount is realized. So realization of amount tak you have to make the interest payments, or until the if there is a suit involved, until the court directs you to stop paying up. Section 80, however, is what we have to focus on here. It is a situation where the interest rates are not specified. So, what is the generally you have to go by the specified rate, but if it is not specified, what do you have to do? The interest rates will be calculated at 18% per annum. Okay, and where do these start from? These start from the date on which amount is to be paid. Amount is required to be paid. And again, of course, it operates up until the point where the amount is realized or the court by its discretion,
Yeah.
stops orders for the ceasing of the payments being made. Next, in chapter 6, section 81, deals with the delivery of instruments on payment or indemnification if there is a loss caused. So, delivery of payment. How does the payment how is the payment order to be made per the Negotiable Instrument Act? So far so good. These are concepts which may seem dry, but we just have to sail through them. We have to understand the broad logics and the mechanisms behind it. And as I said, we are mentioning the core provisions here, which are prone to be asked in your examinations and which are prone to be tested. So, Section 81 states that a person liable to pay the amount due on a negotiable instrument uh, is to pay it before payment and is to pay it before payment is entitled to have the instrument. So, delivery of a payment. So, he has to pay it up by delivery time, right? And what does the delivery of a payment? Sorry, I wrote over this. What is the effect of delivery of a payment? It first of all closes the entire thing. It stops the claims against the person, right? So if you're paying it, it closes the entire case. Up until then, you have completed your liabilities, and it indemnifies you against any further claim for you. So how can it be done? If it is a banker, you can do it by certificate of payment. A certificate is given on the foot of a truncated check, right? That is a truncated check, an electronic form check. And this certificate becomes prima facie proof of payment, right? So that was making the delivery of payment all closed. Now we move on to chapter 7, that is discharge of liability on negotiable instruments. Now, we talked about all the extensive liability of the parties involved in negotiable instruments. Is there a possibility where they are discharged? Yes, Chapter 7 talks about that. There can be various modes of discharge. You can discharge a person from liability by cancelling the release payment, so it can be cancellation, or by allowing drawee more time. So, if you extend the time period above 48 hours, you are extending their liability, you are discharging them basically from the liability to pay then and there. Or you can create a delay in the presentment of checks, right? Or discharge can happen if the endorser's sign is found to be forged, or if there is qualified acceptance, or if there is a material alteration of the instrument. Okay, so these operate as forms of discharge of liability, right? So you can do the cancellation by releasing the person, or you can do the cancellation by making the full payment, right? And section 82 deals with it. You can allow the drawee more than 48 hours to make the payment, right? So a holder of bill of exchange generally allows the drawee 48 hours to make the payment. So sorry, not to make the payment, but to accept whether he to see whether he will accept or reject the proposal for presentment. And he can take more than those for 48 hours, right? So by this, all the previous parties who do not consent to this allowance are discharged from from liability because you extended the time period after 48 hours. So there is a discharge of liability for all the prior parties. Then if it is there is a delay in presentment, if there is a damage or anything, right? Section 84. So if the holder fails to submit a check within a reasonable amount of time, there is a damage due to this towards the drawer himself is discharged from liability to his extent of damages, right? Then or you can do it by making payment, right? On the other hand, you can make the payment. Section 85, if it is a check payable to order, if it is a check payable to order and the drawee is discharged by payment, right? The drawee may be discharged by payment. Section 85 talks about it. He can be discharged by payment either when it purports to be endorsed by the payee, or when the check is expressed to be payable to bearer and the drawee is discharged by payment. There is that. Or if there are parties who don't consent to be discharged by qualified or limited acceptance, right? So if as a holder of a bill of exchange, if you agree to accept a qualified acceptance, right? A qualified acceptance, because otherwise it must be unqualified. You're waiting for the drawee to make the acceptance or not. If the drawee makes a qualified acceptance and you accept it, so any prior party who was not willing for that qualified acceptance is discharge of liability because the things are no longer flowing in their interest. So prior parties are discharged here. But if the holder notifies the prior parties that, hey, the drawee told us that the acceptance is qualified, are you agreeing to this? If they agree to it, their liability continues. If they don't agree to it, their liability is done. And material alteration. So this one right here was in section 86, as I was saying, and section 87 deals with material alteration. So if there is a material alteration of the instrument, it becomes null and void against anyone who was a party to it before the material alteration, because a material alteration makes the instrument something which it was not when you consented to it. So now its liability, your liability with respect to it, ends. Okay, is everything clear so far? You are encouraged to make use of the comment section. We are nearing pretty much the end of the session. We don't have a lot to discuss. We just have to discuss the powers of the courts, cognizance of offenses, the offense, and of course, dishonor. All right, so just let me know in the comments if everything is all good. Right? So let us move on to chapter number 8, which deals with dishonor of negotiable instruments. So dishonor just means losing honor in the instrument. That means you cannot realize the payment anymore. And it has a certain effect, of course, on all the parties involved. Right? So dishonor of an instrument can happen either due to non-acceptance, which is dealt with in section 91, or due to non-payment. Right? So let's take up section 91 first. So if the drawee does not accept the bill of exchange within 48 hours, there is no acceptance. It is deemed to be non-accepted and thus dishonored. Or where the presentment of acceptance is excused and the the bill of exchange remains unaccepted, or where the drawee is not competent to contract, or where the drawee is a fictitious person, or where the acceptance is qualified. That is also a ground for dishonor, actually. Right? So, in fact, in the case of K. Venkata Subhaya versus P.R. Rao Tobacco, a promissory note was held to be dishonored where it was issued by a registered mail and the party that was responsible for receiving it refused to accept it. So, a refusal of acceptance here operated as a reason for dishonor of the bill of exchange. Okay, dishonor of the promissory note. There was a promissory note in this case. Right, so these are the grounds for dishonor due to lack of acceptance or non-acceptance, and the non-acceptance may happen for a variety of reasons which we have discussed here. And dishonor by non-payment is discussed in section number 92. So simply it is where the bill of exchange, acceptor, maker of a promissory note or the drawer of a check makes a payment default. He does not just pay, he doesn't pay up, and that makes it dishonored. Now, when a dishonor happens, we talked about this many times before. The notice of the dishonor must be given. Notice of the dishonor must be duly given. So, by whom should this notice be given? To whom should this notice be given? Is discussed in section number 93. So, the holder or the party that is accountable under the instrument has to send the notice. So, we can say that the holder has to send the notice, and all the people that the holder intends to hold accountable for the dishonor must be notified. But all these people exclude the maker, acceptor, drawee, right? So he must give the holder or the party accountable under the instrument, that is, these parties, they must give a due notice of dishonor, right? So, due notice of dishonor, mention why it was dishonored. Was it due to non-payment? Was it due to non-acceptance? Okay. So, what happens when a instrument is dishonored? The holder loses his suing powers with respect to previous parties. If a holder is not sending this due notice of dishonor, he cannot sue the previous parties, right? So he loses his ability to sue the previous parties who were entitled to the notice of dishonor if he does not send them this notice of dishonor. Now, how may this notice be sent? Talked about in section 94. You can send it in oral form or written form. You just have to send it within reasonable time, and you have to send it to the duly authorized agent or the legal representative or the assignee, like we discussed. Duly authorized agent to any person, legal representative for a person who is dead, assignee for a person who is insolvent, and you have to send it to the official place of residence or business. Then we come to a situation where the instrument is deposited with an agent, not the drawee, but with an agent for presentment. The agent also is entitled to give the same section number 96, where you are consulting an agent, where you are handing it over to an agent for presentment. The agent is entitled at the same time to give notice to his principal that this thing has come over for presentment. So the agent has to act promptly, because we know that there are 48 hours, and a lack of answering in 48 hours might create a dishonor of the entire instrument. So he has to act as if he himself was the holder of the instrument, and he has to tell his principal promptly so as not to exhaust the period required. Now, section 98 tells us about situations. Again, we talked about situations where presentment may be unnecessary. So, there are situations when notice of dishonor may be unnecessary. So, It can be a situation where there is no intention to make the party liable, to make prior party liable. So if the holder does not want to even sue the prior party, he does not have to send them the notice. Where the prior party has signed the endorsement without recourse. If the prior party has made this mention in the signing of the endorsement, they won't be, you won't require to send them the notice of dishonor. If the prior party is incompetent, again, if the drawer is fictitious. Also interesting if where the drawer and drawee are the same person, right? So, and a few other reasons, these are mentioned in section 98, which state that notice of dishonor will become unnecessary or not necessary. Now, chapter 9, dealing with noting and protest. We'll understand what noting is, and if there is no noting, there comes the concept of protest. Noting and protest. Sections 99 through 104A are discussed here. So, noting is just a way of proving or authenticating whether a check has been dishonored or not. So, where a check becomes dishonored, the holder has the option of going to the notary public and certifying that it has been dishonored. Okay. So a notary public is an official representative of the he's appointed by the government, right? So the drawer may go to the notary with his direction, tell him the specifics regarding why the dishonor happened, so that there is documentary evidence. The notary will present the invoice to the drawee and request payment for making such a dishonor noting. And if the payment is made, the notary official will sign it and state that this bill has been dishonored. These are the reasons for dishonoring, right? So he will write down the declaration. What happens is, so I briefly told you about the process that the notary public follows in noting, right? By noting, you just acknowledge that a particular check has been dishonored, and these are the reasons. You certify it has been dishonored, and you write down the reasons. So there is documentary proof of something being dishonored, so that tomorrow it does not become a legal liability for the people involved, for the parties involved, for the subsequent prior parties involved. Section 100 talks about protest. So, what the notary public issues, the thing that he issues is called a protest. So, simply, the protest is a document which attests the dishonored status of the bill. So, the thing that we talked about, all of this, the document that he does all of this in is called the document of protest, right? So, that is the document of protest. Now, additionally, section 100 talks about protest for better security. Protest for better security. So, when the acceptor of a bill of exchange has become insolvent or his credit has been impeached publicly before the bill has become mature, the holder may, within a reasonable time, now the acceptor is facing this fate. What does the holder do? The holder, in reasonable time, will go to a notary and demand better security of acceptor. Right? And if this better security is being refused, he has to get those facts and reasons noted, right? He has to get such facts and reasons noted, and that certificate, and these are noted in a certificate, which is called a certificate for protest for better security. So, that is another term you'll see appearing, not quite often, but you might see it appearing. So, section 100 elaborates upon it under protest, a protest for better security. So, where the acceptor is in a tough situation, the holder may approach the notary That is a protest for better security. What is the content of a protest to be? Section 101 talks about it, right? So you can have, right? You just have to have the name for a person for whom the protest instrument has been protested. You have to have the statement, right, of demand that we need this protest. So a statement that the payment, acceptance, better security has been demanded by a person. Person A is demanding the public notary to issue this protest, and this is the response of the public notary. Or you need the instrument itself that has been dishonored, or a literal transcript of the instrument. You need the place and time of dishonor, and you need the place and time of uh, if you are refusing, if the instrument has been refused or it has been, dishonored because of non-payment. You need the place and time for that also. And you need the subscription of the notary who is making the protest. So these are generally the contents of the instrument and contents of the document, which is called the protest. And then, of course, law requires that you give a notice of the protest. So there are certain bills of exchange or promissory note which are required by law to be protested, but because some dishonors may be required by law to be certified, some checks that are dishonored, law may require some instrument, bills of exchange, etc., to be some checks to be declared as dishonored through protest. And if such is the case, those instruments are required to be declared to be dishonored. The protest also is required to be sent in notice. So you have to send a notice of the protest. Again, the notice in this case will not be given by the person, but it may be given by the notary public who is making such notice that such thing has been dishonored, and this protest is proving that this thing has been dishonored. Now we move on to chapter number 10, which talks about reasonable time with respect to all the realizations of payments, acceptances. What will you reasonable time refer to? Chapter 10 talks about reasonable time. We have sections 105 through 107 only to cover here. So reasonable time is referred to as, where you talk about reasonable time, you have to consider the nature of instrument, the natural or the usual course of dealing with it, and that will tell you the reasonable time required for it. Section 105 generally speaks about it, and it also says that in doing so, you have to exclude public holidays. Then is section 106, reasonable time of giving notice of dishonor. Reasonable time, but for which thing? Giving notice of dishonor. It talks about that. Section 107 talks about reasonable time for transmitting notice of dishonor. Right? So these were the three sections. We'll move on to chapter 11, dealing with penalties. A very, very important, in fact, in my opinion, the most important chapter in NIA. Right? 138 through 147 will be discussed here. 138 is your check bounce. So dishonor of check for insufficiency in funds, etc. So in 138, dishonor happens due to insufficiency of funds. The requirement is that the check is issued for the payment of a legally enforceable debt. The requirement, other than that, is that the check is duly presented within 3 months from the date on which it was drawn. So no longer than 3 months must elapse between the date on which it was drawn, the date that is borne on the check, and the payee must make the demand of payment within a written notice to the drawee within 30 days of the bank notifying him that, hey, this check is dishonored because the holders, because the person who wrote this with the drawer, who sent you this check, does not have sufficient funds. So within 30 days of the bank's receipt, the drawee again has to make a written demand for payment. Then after that, the drawer should fail to pay within 15 days of the receipt of this notice. Okay? So these are the circumstances in which you can say that Section 138 dealing with dishonor of check due to non-payment, due to insufficiency of funds applies. So if the drawer then fails to provide the sum within 15 days of receiving the drawee's written notice, written demand, what happens? The payee after has to write a complaint within 1 month of the failure, within 1 month of the expiry of those 15 days, that this is a case under section 138, so that 130, an action can arise out of 138. We have to know that section 138 creates an offense which is non-cognizable and bailable. Okay. So here 139 illuminates a bit further and states that there is a presumption in favor of holder. It states that unless the contrary can be proved, there is a presumption that exists in favor of holder of a check, right? Uh, that the person who has the check, he received a check that in whole or part. So basically you're presuming innocence on part of the holder himself, right? So you're not presuming that the holder himself is at fault, because he is otherwise also suffering already because of the non-payment. He is going through losses, so you have to presume in favor of the holder that he has in fact received a check which is being dishonored because of a failure of the because of a lack of funds in the bank account of the drawer. Then section 140, very important. It states that it shall not be a defense for a person who is liable under section 138 to say that I believed that the account had sufficient funds. I believe that the check would not be dishonored when I presented it. Okay, it shall not be a defense. So he cannot plead ignorance of the reasons which caused the dishonor, right? So section 140 is very important. Section 141 extends section 138's offense to companies. So if a company issues such a check, every person who at the time of the commission of that offense was in charge of that company will be liable, was responsible for the conduct of the company will be liable, and the company as a whole in itself will be held to be liable for the dishonor of the check and deemed to be guilty of the offences. But the exception in 140, although, is that the concerned person can prove that the offence was committed without his knowledge, or he made due diligence to prevent the offence from being committed, he can excuse himself from liability due to that. Now, who will take the cognizance of this offence created under 138? Section 142 talks about it, says that the cognizance of offense created under 138 can be taken only where there is a written complaint. We talked about the complaint being written within 1 month of such failure of the drawer to provide the money. So only written complaint, and who makes this? Holder in due course, which can be a representative of some sort of the payee of the check, or it can be himself. And the limitation period we talked about was 1 month from when the cause of action happens. We talked about this already. He has to write this complaint within 1 month. And the court that takes cognizance here is the judicial magistrate first class or the metropolitan magistrate. These two are empowered, right? And of course, those of these within whose territorial jurisdiction the case comes. Section 143 goes on to elaborate the summary trying powers. So 143 states that the courts may try these summarily. Section 138, the offense under Section 138, right? It may be tried summarily. Okay, so the conviction in a summary trial may be as such that the judgment passed by the magistrate can be that the imprisonment may be up to 1 year plus a fine of up to 5,000 rupees, right? Or there can be a situation where the magistrate thinks that imprisonment over 1 year needs to be passed, right? Imprisonment of over 1 year needs to be passed. It states that sections 265, 265, 262 through 265 of CRPC apply. Section 143 states that 262 through 265 of CRPC apply to these proceedings. These are the sections dealing with summary trials, and these apply to trials of offense under Section 138 of Negotiable Instrument Act. Okay. Then, with respect to all this trying and the action of the court, 144 talks about mode of service of summons. Of course, the mode of service of summons is just you have to serve upon them in the place of residence, in the place of carrying out of business, or where you personally work or work for gain. You are personally working for gain, and the mode is courier or speed post. And then 145 talks about reception of evidence on affidavit in these proceedings. So evidence is taken on affidavit. Okay. And we talked about the presumption in favor of the holder of the check in case of offense under 138. Again, 146 talks about the bank slip being a prima facie evidence of the dishonor, right? Or certain facts. Section 146, the bank's slip is held to be important. It is a presumption. Because of this, the court presumes that the check was dishonored. Section 147 simply states that the offences under Chapter 7, that is the offence under 138, shall be compoundable. So if we look all in all, the offence is non-cognizable, compoundable, and bailable. Okay. So an important question that arises many a times, the offence under NIA, the offence under Section 138 of NIA, or the offence under Chapter 10 of NIA is what? What is the nature of the offence? It is compoundable, it is non-bailable, it is non-cognizable, and it is bailable. All right. So guys, that was the very last section. I hope this was helpful, and I hope you enjoyed the session and it helped you walk through many concepts of NIA. Make sure you are relentlessly pursuing the mock tests, the quiz sessions, and the rapid revision sessions, because that is what will give you a well-rounded perspective and a well-rounded preparation strategy for the exam. Take care of yourselves and all the best. Make sure you have attempted today's full-length mock. It is the final full-length mock. And have a good day, and thank you for being here. Thank you for your patience. Have a very, very wonderful Sunday with the examination, and please update me on the results as soon as you come out. We'll all be waiting and we all rooting for you. Congratulations on all the hard work you have put in so far. Thank you guys. Bye.